Well, good morning, everyone. I want to thank the speakers for agreeing to participate in this workshop. And secondly, I want to apologize for my poor English. This seminar, entitled Challenge for Medium-Sized Language Communities in the Global Era, a Juridical Perspective, is part of a project dedicated to the most wide study of medium-sized language communities. 2 years ago, it was held a first workshop to define the medium-sized languages communities and to see what were the challenges faced in an increasingly globalized world. The contributions of this seminary is now in course of publication, pending of the final approval by the editorial Linguistic Matters. At that seminary, the participants were sociolinguists. Last year, we started a new research on the difficulties and challenge of language medium-sized communities, but from a legal perspective. So it was performed a seminary like today, so divided into 2 sessions in which we studied the cases of 2 communities, Belarusian and Czech communities, the problems for medium-sized language that entail supranational organizations such as the European Union, and the challenge in a particular sector, which was the sector of universities and culture. In this seminar, we also go to study the challenge in both communities, the French community in Quebec and the Estonian community in Estonia, the incidence of international and supranational organizations, and what happens in the fields of media and cinema. Our aim is to send at the end of this year to publish all the text of last year and the text of this year together to the prestigious editorial Linguistic Matters for publication. This explains why we have decided to make the seminars in English. Well, the speakers will have 30-40 minutes for speak, and after that 10 minutes for discuss. Nothing more. I can only welcome everyone and go to present the first of the speakers. The first of the speaker is André Bras. André Bras is a professor in Ottawa University. He is a specialist in administrative law and also in maritime law, but he has specialized in linguistic rights. He has published a lot of works, and he's well known here in Catalonia because he has been invited in another ways. No? Well, thank you very much, André, pour être ici avec nous. Bienvenue.
Merci. First, let me thank you very much, the person in charge of the organization of this workshop, for their very kind invitation. It's a privilege for me being here this morning with such an audience. And it's also a great pleasure, of course, being in Barcelona. So, such a wonderful city. As you know, Canada has 2 official languages, French, which is spoken mostly in Quebec, and English, which is the common language used in the rest of Canada. According to the year 2006 census, Canada had a population of 32 million. 98% of the population can speak one or both official languages. There were 18 million Anglophone, about 7 million Francophone, and 6 million allophone. An allophone is a person whose mother tongue is neither French nor English. The proportion of Francophone is declining constantly, and it represents 23% of the total. About 4% of the French population live outside the province of Quebec. The Chinese language was the 3rd largest mother tongue group in Canada, after the Francophone, and probably today is the 2nd largest group. In 2006, the population of the province of Quebec was about 7.5 million persons, 6 million of of francophone, 587,000 anglophone, and 886,000 allophones. The anglophone population of Quebec has historically benefited from almost total language transfer of allophones towards English. But for the first time, in 2006, 51% of allophones adopted French as their main home language in Quebec. That is to say that as a medium-sized language community, as you call it, the French community in Canada competes with the English language used massively, not only in Canada, but also in North America. In fact, on a continental scale, 1 person speaks French and 55 speak English. I have been asked to present the legal measure taken by the province of Quebec for preserving and promoting French, to explain what are the main constitutional limitations regarding this action and what are in Quebec the challenges French will be facing in the future. So let me about 40 minutes to go through this program. Before the adoption by the National Assembly of Quebec in 1977 of the Charter of the French language, the English language was a language used for doing business in Quebec, and French was a language used in small enterprises and also the language of the cheap labor. Francophone did not occupy and play an important role in the economy, and immigrants in Quebec chose English as their common language and sent their children to English school. Today, the inequalities on the economic level have disappeared, and this is surely the most brilliant success resulting from the Quebec politics, particularly in language matters. Now immigrants have to send their children to French school. Does it mean that the Charter created the new balance favorable to French, assuring once for all its status and its predominance in the Quebec society, and also assuring what is called the paix linguistique? For a long time, Quebec government were concerned about the quality of French and its status in the province. The Office de la Langue Française was set up in 1961 in order to promote the quality of the French language spoken in Quebec. In 1969, Quebec legislature adopted an act to promote the French language, a measure strongly disputed because it gave parents the right to send their children to French or English schools according to their free choice. In 1974, and for the first time, French was declared the official language of Quebec, and free choice in education was abolished. 3 years after, the Charter of the French language was adopted. Today, Quebec policy over the French language is structured mainly around the Charter and the 29 regulation passed for its implementation, and also around some specified governmental policies taken in various matters. For example, the policy for the use and the quality of French in public administration. Now let me turn to the content of the Charter of the French language. But first, you shall recall that in the years following the adoption of the Charter of the French language, and even very recently, many provisions of the Charter were challenged before courts and were invalidated. These court decisions led to many amendments which were brought to the original version of the Charter. In its preamble, the Charter of the French language expresses the will of the National Assembly of Quebec that French becomes the normal, the everyday language of work, instruction, communication, commerce, business, in a spirit of fairness and respectful of the rights of the English-speaking minority and of the Aboriginal communities. Section 1 of the Charter declares that the French is the official language of Quebec. Section 2 to 6 provide an individual with what is called fundamental language rights. First, the right for every person to communicate in French with the civil administration, the health and social services, the public utility enterprise, and the professional orders, the association of employees, and with all enterprises doing business in Quebec. 2, the right to speak French in deliberative assemblies. 3, the right for workers to carry on their activities in French. 4, the right for consumers of goods and services to be informed and serve in French. And 5, the right to receive instruction in French. The government, as it stood when the Charter was adopted, asserted its will to make French the usual and common language in Quebec. The first version of the Charter proclaims that the French is the only official language of the legislature and of the courts, but its provisions were invalidated by the Supreme Court of Canada. Today, Chapter 3 deals with the language of the legislature and the court. And Section 7, with the caution, stipulate that the French is the language of the legislature and of the court in Quebec, but this assertion is made subject to the constitutional limitation that are, first, bill must be printed, published, passed, and assented in French and in English, and statute must be published in both languages. 2, regulation of the government must be published in French and in English. 3, the French and the English version of this legislation are equally authoritative. Either French or English may be used in judicial proceeding before court, and judgment rendered by a court or by a quasi-judicial tribunal shall be at the request of one of the parties, translated freely in French or in English. Chapter 4 of the Charter governs the language of the civil administration. French is the official language of the public administration. Text and other administrative documents are published in French, but other language may be used by the civil administration regarding its relation with persons outside Quebec or regarding notices sent to Anglophone media and in correspondence with individuals who have written to the administration in English. The government, its department, and all other public agencies shall use French in their written communication with other government and with legal persons. French is the language of work and communication within the civil administration and is used in internal communication. In order to be appointed or promoted to a position in the civil administration, a person must be competent in French. Notices published by the government must be in French except where public health or security require the use of English. Certain categories of administrative office may benefit from a different language regime. These include municipalities with an important English-speaking population, health and social services institutions which provide their services primarily to an Anglophone clientele, and the school of the Anglophone minority. These organizations can provide notices in French and in English and use French or English in their internal communication and in communication amongst themselves. There is no explicit provision in the Charter recognizing the right to government services in English, but the Act respecting health services and social services confers on an English-speaking person the right to receive health and social services in the English language. According to Chapter 5 of the Charter, French is to be the primary language for semi-public agencies, that is to say public enterprises and professional corporations. In the last case, and for example, Section 35 states that the practice permit shall not be issued by a professional order to a person who does not have the appropriate knowledge of French. Exceptions are made for professionals from outside Quebec and for professionals not in direct contact with the public. Chapter 6 is entitled The Language of Labor Relation. The employer shall use French in the written communication to the employees, and collective agreement shall be drafted in French. Dismissing, laying off, or transferring an employee for the reason that this employee has not a sufficient knowledge of a particular language other than French is prohibited. But the Charter does not prohibit that the knowledge of another language may be an hiring condition when obtaining an employment or office and when this knowledge is required for carrying out this employment or office. Every association of employees shall use French in its written communication with the members. In a correspondence with an individual member, another language may be used. A Francisation program must be set up by an enterprise having 50 employees and more. This program shall focus on the use of French as the language of work within the enterprise, and a certificate is issued when the use of French is generalized at all levels of the enterprise. Chapter 7 deals with the language of commerce and business. Every inscription on a product and the direction for use and the warranty certificates must be drafted in French. The same applies to menu and wine list. But translation in other language is permitted, but shall not be given greater prominence than that in French. Catalogue and commercial brochure are to be drawn up in French. Computer programs, software must be available in French unless no French version exists. Public signs, poster, and commercial advertising must be in French. They may also be in French and in other language, provided that French is markedly predominant. But the Charter and its regulation provide numerous exceptions to the rule in the cultural, religious, and political area. Finally, Chapter 8 deals with the language of instruction. Instruction in the kindergarten and in the elementary and secondary school shall be in French. But, and according to Section 23 of the Canadian Charter of Rights and Freedom, the Charter of the French language contains provision that confer on Anglophone parents the right to have their children instructed in English school. Finally, take note that Section 89 states that where the Charter does not require the use of French exclusively, French and another language may be used together. Now, regarding the, the constitutional limitation. Since its adoption in 1977, the Charter of the French language leaves a significant number of legal challenges in its wake. Many of its provisions have been challenged before the courts, which have shown what are the limitations imposed by the Canadian Constitution on the Quebec Authority to promote French on its territory. What are these limitations? The first limitation comes out from the distribution of powers, as entrenched in the Canadian Constitution. Canada is a federation of provinces, and each level of government, federal and provincial, may make law in its areas of jurisdiction. As such, language is not an enumerated head of power in the Constitutional Act of 1867. Rather, language is an area of concurrent jurisdiction. It means that each level of government may make law in areas of its own jurisdiction and regulate language matters coming with them, as long as in doing so, enshrine or constitutional rights are not violated. Therefore, Quebec, in legislating to make French the official language of the province, is incompetent to apply its law to undertaking that fall within the legislative jurisdiction of the Canadian Parliament, such as federal governmental agencies, federal crown corporation, banks, shipping lines, airlines, railway, radio and TV, and other undertaking engaged in interprovincial or international transportation or communication. Regarding these undertakings under federal jurisdiction, it's the language legislation adopted by the Parliament of Canada that applies to them. For example, it means that the provision of the Charter of the French language, making French the language of the labor relation, do not apply to about 300,000 employees working in these undertaking under federal jurisdiction in Quebec. If Quebec makes French its official language at the federal level and according to the Constitution and also to statutory law, French and English are the two official languages. Therefore, and for the federal purpose, English and French have equality of status and equal rights and privileges as to their use in all institutions of the Parliament and Government of Canada, including those located in Quebec. The Official Language Act was first adopted by the Canadian Parliament in 1969 in order to promote French in Canada. At this moment, English was massively used in Quebec and French was almost absent outside Quebec. Therefore, the federal legislation today assures a minimum of visibility for French language outside Quebec, but with irony competes with the Charter of the French language in promoting equality of status for French and English in Quebec. Second, in regulating language matters falling within its jurisdiction, Quebec cannot conflict or violate the language guarantee enshrined in the Constitution as interpreted and applied by the court. What are these guarantees? The provision of the Charter respecting the legislature and the courts, when first adopted in 1977, were held unconstitutional. Section 133 of the Constitutional Act of 1867 imposes the compulsory use of French and English in Parliament of Canada and in the legislature of Quebec. This provision entrenches the right of members of Parliament of Canada and of the National Assembly of Quebec to use English or French as language of debates. The Court of Appeal of Quebec explained that the founders of the Confederation intended Francophone residents to have the opportunity to participate in debates of Parliament on an equal basis with Anglophone residents. By way of reciprocity, Anglophone residents were given the same right with respect to the legislature of Quebec. Therefore, documents drafted only in French and forming an essential part of bills presented to the National Assembly violate Section 133 because an unilingual Anglophone voting on the bill might remain ignorant of the content of the document. Under this Section 133, Canadian Parliament and the Quebec Legislature have the obligation to keep their record and journals in French and in English, and they are also under the duty to print and publish their laws in both languages. The Supreme Court of Canada has ruled that this obligation for statutory bilingualism applies to the printing and publishing of legislative enactment, as well as their adoption process, with the latter requirement being implicit. This obligation to use French and English also extends to statutory instruments adopted by the government, a minister or a group of ministers, or those regulations that need a government approval before they can be put into force. Courts finally ruled that both versions of a legislative enactment are equally authoritative. Therefore, Quebec cannot, on a constitutional basis, make French the only official language of its legislative process. The same goes for the language of its court and tribunals, because Section 133 of the Constitutional Act 1867 confers on individual the right to use French or English before the court established by the Parliament or by the Quebec Legislature. This right does not include the right to be understood directly without translation, or to be answered orally or by writing in the language chosen. This constitutional provision is seen as being a minimum, and a legislature may add to this minimum, and for example, and because Parliament of Canada has the authority to legislate with respect to criminal procedure, the Criminal Code of Canada has been modified and now allow for criminal trials to be conducted in French or in English everywhere in Canada, including, of course, in Quebec. So French and English may be used before civil and criminal court in Quebec. To this regard, one must remember that bilingualism in judicial proceeding in Quebec is an historical fact and is a well-established practice. First, provision respecting the language of commercial signs and advertisement also were held to be unconstitutional. At the time of its adoption, the Charter of the French language required that commercial advertising and public signs and posters be in French only, and that only the French version of a firm name be used. Those provisions were held unconstitutional because they infringe the freedom of expression guaranteed by Section 2 of the Canadian Charter of Right and Freedom, and these were not a limit that could be demonstrably justified in a free and democratic society. But the Supreme Court of Canada added that the legislative objective of promoting French and of protecting the visage linguistique of the Quebec society is a legitimate goal under the Charter, and that can be done not in prohibiting the use of languages other than French, but in giving French a marked predominance when used on commercial signs and advertisement. For a short time, after the decision of the Supreme Court in 1988, Quebec continued in imposing the exclusive use of the French language, invoking the notwithstanding clause found in the Constitutional Act of 1982. This clause can be used by government in order to overcome a charter decision taken by a court which strikes down one of their laws. Section 33 of the Constitutional Act of 1982 states that Parliament or the legislature of a province may expressly declare in an act of Parliament or of the legislature, as the case may be, that the act or a provision thereof shall operate notwithstanding a provision included in Section 2 or in Section 7 to 15 of the Charter of Right and Freedom. Such a declaration is valid for a period of time not exceeding 5 years. But to this regard, there is a political price to be paid because when such a declaration is adopted by a government, it is very badly received by the public opinion. Today, as we have seen, it is a rule of the prominence of the French language that applies in this area. Finally, provision of the Charter of the French language regarding the language of instruction were many times challenged before the court. Section 23 of the Canadian Charter of Right and Freedom gives qualifying parents the right to primary and secondary education for their children in the language of the minority in the province of residence. This is English in Quebec and French in the other provinces. They also have the right to have this education dispensed in educational institution of the minority and financed with public fund. This section gives the official language minority of each province the right to manage its own educational institution. In matter of minority school, you must keep in mind that unlike the case of the French minority outside Quebec, the English minority in Quebec already had its own educational institution since the Confederation. It exists in the province of Quebec, a network historically well established of public and private schools, providing elementary and secondary instruction in English in Quebec. Moreover, there are also English colleges and universities. So English language instruction has a long and rich history in Quebec. And it was not until the 70s that legislation restricted access to English school. Contrary to the rest of Canada, the question of constitutional minority education guarantees in Quebec is not about the existing facilities and their adequacy or about the right to management and control, but rather concern access to education. If even today the French minority outside Quebec continues in many regions to claim for educational services in its language, rather in Quebec it is not the member of the Anglophone minority but Francophone and Allophone who claim access to English school. The instruction in the minority language of ineligible children is not permitted by the Charter of the French language. Generally speaking, those who are qualified parents under the Canadian Charter of Rights and Freedom have the right to send their children to English school in Quebec. The Canada Clause had been specifically enshrined in the Charter of Rights and Freedom to invalidate the Quebec Clause contained in the Charter in 1977, when the Charter of the French language was adopted. At this time, the Charter provided that all children whose parents had received primary school instruction in English in Quebec had the right to English language education in publicly funded schools in Quebec. The Canadian Charter of Rights and Freedom, adopted in 1982, gave this right to children whose parents had received primary instruction in English everywhere in Canada. This is what we call the Canada Clause as opposed to the Quebec Clause. And of course, the Quebec Clause was found inconsistent. Members of the French majority and members of the Allophone community succeeded in challenging the Charter of the French language, which specified that only children who have completed the major part of their education in English in Canada, and his or her brothers and sisters should have access to public English school in Quebec. To determine if it is the case, the Quebec authorities calculated if the child had spent more months in the English school than in a French one. This strictly mathematical interpretation was ruled incompatible with the purpose of Section 23 of the Canadian Charter. And according to the Supreme Court of Canada, in the case of Solsky, the framers of the Canadian Charter intended for this guarantee to provide continuity of minority language education rights, to accommodate mobility, and to ensure family unity. Section 23 did not specify the time a child had to spend in a minority language school in order to benefit from the constitutional guarantee. What is required is that the child had spent a significant part of his educational pathway in the language of the minority. And the question to ask is, does the child have an intention to adopt the minority language as a language of instruction? So, this case of Solsky creates a new category of children having the right to access to the official language minority school. And it means that the constitutional guarantee is not only for the members of the official language minority as traditionally defined, but also for members of the French majority and of the allophone community. For sure, this ruling is not concerned with the intent of Quebec to promote French. A last case deals with the phenomenon of bridging school in Quebec. Parents whose children were not entitled to receive publicly funded education in English according to Section 23 of the Canadian Charter first enroll them in a non-subsidized English school. It's a private school running without any fund from the government for a short period of time, 5-6 months, and after ask the Department of Education of Quebec a certificate permitting the children to access to English publicly funded school. The charter was amended in 2002 in order to stipulate that time spent in a non-subsidized English school cannot be taken into account when determining if a child can have access to an English publicly subsidized school. The amendment was held unconstitutional because, according to the Supreme Court, Section 23 of the Canadian Charter does not specify whether the education received or being received has to be private or public. Very recently, the Quebec government adopted a law that complies with this decision, and now it is permitted to take into account the time a child has spent in a non-subsidized English school in order to determine whether or not this child can claim access to public-funded English school. Francophone and allophone parents who have money now can buy a constitutional right. In one sense, it's a return to the freedom of choice regarding the language of instruction for those parents who are capable to send first their children to a private and non-subsidized English school for 1 or 2 years and afford, of course, this expense. Note that regarding access to English colleges and universities in Quebec, free choice already exists. The court's interpretation of Section 23 of the Canadian Charter is mostly based on the need to protect linguistic minorities and not on the right of Quebec to protect and promote its language and culture. Generally speaking, the approach taken by the Supreme Court in language matters is to treat equally official language minorities, English in Quebec and French in the rest of Canada. But this approach does not reflect reality. The precarious status of Francophone outside Quebec does not compare to that of the well-established status of Anglophone in Quebec. The two minorities are not on an equal footing. It can be said that, except in few cases, the Supreme Court of Canada ruled constantly against Quebec policy in matter of language in considering first the right of an individual rather than the need of Quebec to protect its culture. For example, the general purpose of Section 23 of the Canadian Charter is to counter the assimilation of linguistic minorities. The fact is that assimilation endangered the francophone outside Quebec and not the anglophone in Quebec. Quebec wants to integrate immigrants in the French educational system, but this intent is now set aside with the Supreme Court of Canada decision in the case of Nguyen. And now, what are the challenges French will be facing in the future? And I will conclude with it. Today, in the province of Quebec, and it is particularly true in the Montreal area, where is gathered half of the Quebec population, when two persons having a different language want to communicate with each other, they use English. Even if French is the official language, it remains that most of the time the common language used in Quebec is English. French is the official language, but Quebec remains largely bilingual. How to really make French the common language in Quebec? First, the Charter of the French language shall be implemented in a real and concrete manner, despite the fact that the Charter declares French the official language of the civil administration. For many years and up to now, services offered by public administration in Quebec are almost the time systematically offered in French and English. So an individual feels free to choose a language of communication. Regarding the city of Montreal, for example, the law stipulates that Montreal is a French-speaking city. Nevertheless, municipal services are generally provided in a bilingual manner. The pretext given in order to justify this practice is that the Charter does not prohibit the use of a language other than French. Therefore, nothing forbids the use of English with French. This interpretation of the Charter is a literal one. It may be correct on a strict legal point of view, but it surely goes against the purpose and objective of the Charter of the French language. Normally, and in matter of public services, it is the duty of the recipient to adopt the language of the state administration and not the opposite. Except for health and social services, and except for the bilingual institution as provided by the Charter, and where both languages may be used, French shall be truly the language of the Quebec civil administration. Because the aging of the population and the low rate of birth, immigration is essential for Canada and Quebec. As I already said, the English minority in Quebec has historically benefited from language transfer of immigrants towards English. It remains that today, after 35 years of implementation of the Charter of the French language, barely half of the total immigrants have chosen French as their common language. But it also means that the other half chose English. High rate of newcomers' linguistic transfer to English is due to the socio-economic attractiveness of English as compared to French. In the rest of Canada, 97% of all immigrants adopt English as their common language. The fact that a larger proportion of selected immigrants have already French as their mother tongue, or a good knowledge of it, explain the increase of the number of immigrants choosing French in Quebec. A recent report shows that persons having French as their mother tongue will be in the minority on the island of Montreal within the near future. Not because of the increase of the Anglophone population, but because of the increase of the number of allophone. Actually, 50% of the Montreal population are Francophone, 17% are Anglophone, and 33% are allophone. Considering Quebec's will to integrate newcomers in its culture and language, attention must be paid to the language spoken in the workplace and to the language of the educational system. Clearly, workplace and school are the two places permitting immigrants to integrate well into a society. Francization programs under the Charter of the French language have functioned well in workplace. This constitutes a strong incitement to the use of the official language, but programs apply only to enterprise having 50 and more employees and does not apply to small business. Should All business with 3 employees and more have to comply with the requirement of a francization program. The question shall be raised in the Montreal area, and according to a survey, it seems easier for a unilingual English-speaking person to find a work. It seems also that the knowledge of English is a constant prerequisite for being hired by a company, whatever is the office or employment to be held. When served in English, a francophone often prefers to speak English rather than insist on being served in French. On the one hand, French schools are asked by the government to give French lessons to newcomers in Quebec. And on the other hand, the same government pays English lessons to immigrants because English is often a condition to be hired by a company. If the French language shall be normally used in education, it remains that freedom of choice is the rule for colleges and universities in Quebec. According to certain surveys, 7% of the francophone students and 60% of the allophone students enroll in an English college after completing their secondary school in French. It exists in Quebec a strong confusion between bilingualism as a personal feature of an individual and a bilingual society running in a bilingual manner. Nobody is against the learning of a second language. In Quebec, English as second language is taught in French school as soon as a pupil is enrolled in grade 1 of the elementary program. In a globalized world where attractiveness of English is very strong everywhere, imagine how it is in Quebec in North America. If bilingualism shall be promoted at school, considering the necessity of having a second language, does it mean that the Quebec society itself has to work in a bilingual manner? What shall be promoted in Quebec, French or English? Right now, the true message sent to immigrants by the federal government and also by the Quebec government is you have the choice between French or English. I think that French shall be the object of a permanent promotion policy by Quebec, considering its location in North America and the attractiveness of the English language. But above all, there shall exist a clear will from the Quebec government and also from the Francophone themselves for having French as not only the official language, but also the common, the normal, the everyday language of communication. I think now this will is absent. Francophones seem to be more preoccupied with the question of learning English, English being the language of prestige, than with the quality of the French language learned and spoken at school. Also, the Charter of the French language is probably the most hated law in Canada, except in Quebec, where Francophones generally favor it. In English Canada, the Charter, or Bill 101, brought a general condemnation, and it is seen as being a separatist law that violates individual rights and that fights against English without any valid reason. I think that Quebec is not insensitive to this position. Many Francophones in Quebec, when communicating with an allophone or an Anglophone, instead of insisting to speak French, appear embarrassed and choose English. Probably for the same reason, Quebec government prefers to convince rather than to pursue those who contravene the Charter. Several people in Quebec think that actually there is no political will to really implement the Charter and to build a truly French-speaking society in North America. Quebec is caught between two stools regarding its constitutional status. It appears that the same goes with the status of French on its territory. Thank you.
Thank you very much, André. Then we have 10 minutes for discussion. Emily.
Well, my name is Bosch. I'm professor here of sociolinguistics. I'm not a legal expert. My question is, or my comment, we have been very influenced by the Quebec or Canadian experience, sociolinguistic influence. We have tried to follow your history, your linguistic history. But there are many differences. here there are not two funding nations, for instance. Here there is a main nation, which is the center, and we're in a secondary part of Spain, with a second-class language. That's very different. My question is, to which extent do Canadian, or especially Quebecois population abide by the law? I mean, there are many laws. Are they followed by the, which is the respect of the people feel concerning the law? When they try to follow them, or they try to skip them, or?
Well, it's very simple to answer the question. Normally in Quebec, and polls show that, the French population favor the Charter of the French language. Okay, the French population agree with this law, but to the contrary, the English-speaking population, well, are not really in agreement with the Charter of the Right of the French language. But the Charter of the French language, it's a law, so everyone must obey the law. They don't have the choice. The fact is, many person right now contravenes the Charter of the French language, and as such, the Office de la Langue Française, who is the maybe it's a sign from upstairs. The fact is that the Office de la Langue Française, who is in charge of the implementation of the Charter of the French language, seem not well disposed to sue the person or the people who contravene the Charter of the French language. The office prefer to convince slowly but surely people that it's important for them to obey the Charter, even if they disagree with its provision. So people is bound by the Charter. They have to respect all provision of the Charter, but there are also many violation of the law, and it seems that on an administrative point of view, efforts are made in order to convince those who do not believe in the law, well, to respect the law, rather than suing them before a court.
Thank you.
Another question?
So you think, do you think that the governments have relaxed a little face-to-face all the times in the implementation of the law?
I said that Bill 101 is very bad received by the rest of Canada. And I think that Francophones feel a little bit guilty having such a law and having to apply this law. Why do we have to adopt a law in order to live in the normality, okay? And Bill 101, or the Charter of the French language, was adopted by the Parti Québécois in 1977, a separatist government at the time, okay? And it is well known in our society, I mean in the Quebec society, that the liberal government, even if the government says, well, we favor the Charter of the French language, well, seems less in a hurry to implement really the Charter. We very often say that the liberal government in Quebec, of course, the official speech is Charter of the French language is a very important statute. It's the heart of what is Quebec. Okay, but on the other side, this government seems not very interested in implementing very strictly the Charter. So it may vary from one government to another one.
In dealing with diversity at many levels in Canada and Quebec, I understand that you have the concept of reasonable accommodations and similar things that try to solve conflict more convincing instead of implementing legislation. Do you think that language could be treated this way as well, or it's another scenario that it's more complicated?
Not really, because the Constitution provides specific provision regarding language rights. Okay, and it may happen, for example, when the Charter deals with the language used in commercial advertising. Okay, at this time, if you impose the use of only one language, it has been ruled that it goes against the freedom of expression and so on. So maybe this notion of reasonable accommodation may be used in interpreting a provision, but most of the time, no, I don't think so. Reasonable accommodation is used when you talk about freedom of expression, freedom of religion, and so on. We are talking about the language to be used by the state, okay? The perfect word is, the state will have to speak as many languages as its population speak, but we know that it's not the reality, and you have to choose your language. So.
You talk about linguistic quality at the end of your talk.
Linguistic?
Linguistic quality, the preoccupation about the quality of the language.
Yeah.
Surely, as a linguist, I'm more a linguist than a law expert, then are there any campaigns to encouraging people to use good French? Or?
There is a concern. At the very beginning, when the Office of the La Langue Française was established in 1961, it was for having this question of quality of the French spoken to be from time to time a governmental policy coming from the education department, or very often in the school. There may be a campaign for promoting the quality of the French spoken at school, for example. But I will say that generally speaking, people in Quebec talk more about the quality of the English learned at school rather than the French learned at school. Speaking a good French may be seen sometimes as being précieux, langage précieux. But there are campaigns on this question of the quality of the French language used in Quebec.
I prefer to make a question in French.
Oui, d'accord. C'est plus facile pour moi aussi, hein?
J'aimerais bien poser la question suivante. Vous pensez que les Québécois sont conscients que souvent ils ont un meilleur regard d'un lexique qui est bien plus français et roman que les francophones du reste du monde? Vous pensez qu'il y a cette conscience?
Je crois qu'il y a une petite partie de la population qui sait effectivement que, par exemple, il y a un lexique, dictionnaire terminologique mis en place depuis longtemps par les institutions québécoises et aussi les institutions fédérales à Ottawa en ce qui concerne le français. Il y a un travail énorme et assez spectaculaire qui a été fait de ce côté. Mais je ne pense pas, moi, que la majorité des gens en soient conscients et je ne suis pas certain que la majorité des gens valorisent aussi cette question-là. Les exemples donnés à l'heure actuelle sur la qualité du français au Québec ne sont pas très très bons. La qualité de la langue utilisée dans les médias, par exemple, est assez pauvre. Et on a beau se plaindre, si l'on se plaint, on est mal vu, là, c'est précieux, et ainsi de suite. Mais il y a certainement, je vous rassure tout de suite, là, il y a certainement une minorité de gens qui sont conscients de la richesse de cette banque de terminologie.
Are there questions?
What is the English quality that you just talked about in the school system? I can understand exactly what you said. Is now the parents of the Francophone parents, they probably feel the pressure for having a very good command of English.
Mm-hmm.
So how is going to be solved the problem? I mean, is there a pressure for having more English instruction hours in school?
The pressure was always there from the beginning, because our location, and because for a long time the English language was dominant, even in Quebec. Okay, even today in Quebec, where the official language is French, the population feels this pressure. And being or becoming bilingual is something very important. It means that probably you will have access to a better job, to a better income, and so on. So a good parent wants is a child to become fluently bilingual, French and English. That's why I said that in Quebec, people seem more preoccupied by learning a good English rather than being preoccupied with the quality of the French spoken in the street or at the school. This is a confusion, as I said. Everyone wants to be bilingual. A francophone in Quebec is proud, of course, of his or her language, but I think that he is prouder speaking English, you know. So there is an immense pressure for being bilingual in Quebec.
Do you think that it's going to have political changes in the educational system because of that?
Well, the question is not to oppose to this intent. I think it's normal. Acquiring a second, a third language, perfecto. It's not a good question to raise in Quebec. The question is, do you really want to have a French society in North America? That's it. And having a French society does not mean that other languages are not used. Not at all. Not at all. There is an English minority living in Quebec, and they will continue, of course, to live in English. The question is not, we don't want you to be bilingual. What do you want? What do we want in terms of society? Do we really want a society that runs in French or not? Even if its population is bilingual or trilingual and so on.
In our research, we consider French in Quebec, certainly only in Quebec, a medium-sized language. No? Therefore, a language in danger in the international context. No? Mm-hmm. Then, seeing the pressure of English, do you think that the legal framework of linguistic rights in Quebec suffered to protect French community? or
Well,
it is necessary is a challenge to think, if necessary, to introduce, enacted some changes.
Well, as I said, of course, there are limitations. Considering the constitutional status, actual constitutional status of Quebec, there are limitations. Quebec is not in a position to really implement, let's say, a complete policy in matter of language. There are restrictions coming out from the Constitution. But the problem, it seems to me, is not with this limitation under our Constitution. The problem is with the will of the population. What really want Quebec? We don't know regarding its constitutional status. Huh? We are federalists, we are sovereignists, we don't know what we are, and we don't want to discuss about our constitutional problem, okay? What about the French language? Well, we don't know. We know that we want to be bilingual, but what about French? French is important, but we don't want really to discuss the problem of the French language of Quebec because of the paix linguistique. We don't want to disturb this paix linguistique. When you discuss question of languages in the Quebec or in the Canadian society, you raise, let's say, very sensitive concern, very sensitive issue. And a normal, a prudent government does not like to raise this type of question. So that's why I'm saying that there is not really a true intent from the government to implement the charter as it exists right now.
Mm-hmm. Well, the last. The last. The last question.
I feel a little that the French speakers has evolved a little positively to be from bilingualist to from monolingualist in French to bilingualist, individually bilingualist, French English. But I am afraid that the English speakers in Quebec has not the same evolution like here, and they say, oh, I'm lucky you want to be bilingual, so I can keep myself monolingual. This can be like this there.
Well, being bilingual in Canada means most of the time that it is the francophone who is going to speak the other language, I mean English, okay? It doesn't mean that there are not Anglophone who are bilingual. They are, of course. They are, of course. But when you're talking about bilingualism in Quebec, for example, the pressure is on the francophone. Most of the time, it means that the francophone will use English. It doesn't mean that the anglophone will use French. I would say that the majority now of the members of the English community in Quebec is bilingual. The majority of the English community. But once again, a bilingual Quebec means most of the time that the language use, the common language use, is English and not French. So it means that the bilingual English person in Quebec will continue to use his or her language, English.
Well, thank you, André. Then, José Darling, if you want to come here. Do you use computer? Well, José Berling is associate professor at the law faculty of University of Montreal. Your fields of interest are Canadian and comparative constitutional law, federalism, human rights and rights of minorities, law and cultural, linguistic and religious diversity. He has published a lot of papers about linguistic rights, and he has also participated in different seminars in Catalonia. Then is known for a lot of us. Thank you very much, José, for to be here with us.
Okay, first of all, I must excuse myself for my relaxed attire. I have brought a suit and a tie and shirt with me, but they all are in my luggage, and my luggage has stayed in Rome. So today I have to appear before you and to make my conference in the clothes I'm wearing for traveling. So excuse me. And second, I would like, of course, to thank warmly the organizers of the seminar for inviting me to participate in this seminar and to use the occasion again to come to Barcelona, a city I know well and I like very much. So, you can see from the program, I have been given the task of examining the external challenges for Quebec's language policy, challenges arising from cultural and economic globalization. As you have understood from the presentation given by my colleague André Brun, the main objective of the linguistic policy of Quebec is to protect the position of the French language against the competition of the English language. And it is easy to understand that economic and cultural globalization will affect the position of French insofar as it will increase, whether on the domestic or the international level, the use, the prestige, and the attraction of the English language. Thus, we can agree that globalization will inevitably weaken the position of French relative to English in Quebec and Canada. And any sign of weakening of the position of French will surely prompt requests directed at the Quebec government on the part of French-speaking public opinion for the adoption of new, more forceful measures for the protection of French. And such measures will inevitably further decrease linguistic freedom by imposing new requirements for the use of French and by limiting that of English. Indeed, the following measures have already been proposed in Quebec as necessary to reinforce Bill 101. First, it is proposed to extend to the post-secondary, pre-university level of public education the obligation of all immigrants and of Francophones themselves to attend a French-speaking rather than an English-speaking educational institution. And as you know from the speech given by André Brun, at the present time, this obligation applies only at the primary and secondary education level, the choice between the two systems still being left to the individual at the collegial and at the university level. Secondly, it is already proposed, and André spoke about that subject too, it is proposed to extend to companies with fewer than 50 employees the obligation to use French in their daily operation. Currently, this obligation applies only to companies with 50 employees or more. And finally, it is also advocated to extend the obligation of all immigrants and Francophone parents to send their children to a French-speaking school with regard to non-subsidized private schools. And at the present time, this obligation applies only with regard to public schools and private schools subsidized by the government of Quebec. And this measure is considered necessary in order to neutralize the effect of the 2009 ruling of the Supreme Court of Canada, of which André has spoken before and which he explained to you. If such measures were adopted, they would immediately be challenged as contrary to the rights and freedoms guaranteed in the Canadian Constitution, but also as contrary to the rights and freedoms guaranteed in the international instruments on human rights and rights of minorities to which Canada is a party. And to follow the instruction given by the organizer of the seminar, I will first examine the constraint that exist for the linguistic policy of Quebec or for any similar linguistic policy, like that of Catalonia, of course, as a result of the rule of international human rights law applicable to Canada and Quebec. And in a second part, I will also examine the constraints imposed on the linguistic policy of Quebec or any similar linguistic policy by the rules relating to international trade and the economic integration of North America. So my first part is a constraint deriving from human rights and minority rights in international law. To analyze the impact of international human rights instrument on the Quebec policy, it is necessary to begin by establishing two important analytical distinctions. The first distinction is between special or specific linguistic rights relating expressly to the use of languages on the one hand, and the more general universal human rights which do not have an express or direct linguistic content, but which are likely to be interpreted as conferring a certain indirect and implicit linguistic protection on the other hand. That's the first distinction. The second distinction that needs to be made is between the protection applying to the use of languages in private matters, private interpersonal relations, on the one hand, and the rights existing in relation to the official use of languages in the relation between individuals and the state on the other hand. So let me explain the first distinction. Special linguistic rights as distinguished from general human rights with an indirect and implicit linguistic content. In international law, as well as in the constitutional law of liberal democracies, there are two categories of rights and freedoms that are likely to have an impact on domestic linguistic policies. On the one hand, special rights recognized to the benefit of certain categories of minorities and intended to protect, among other things, the right to use the language, mainly with respect to their private interpersonal relations, but sometimes also with respect to their relation with public authorities. For example, Article 27 of the International Covenant on Civil and Political Rights, of which I will speak a little bit more later. On the other hand, general human rights and freedoms, not explicitly or directly addressing the use of languages, but likely to be interpreted and implemented as protecting indirectly and implicitly certain linguistic freedoms, almost exclusively in the sphere of private interpersonal relations. As an example, and André has spoken of that too, freedom of expression has been interpreted as containing implicitly the freedom to use the language of one's choice in certain situations. For the time being, the guarantees regarding the official use of languages that are contained in the international instruments applicable to Quebec and Canada are quite modest. Such guarantees derive mainly from Article 27 of the International Covenant, and I think that the content and interpretation of this provision are very well known, and I will not address this subject in my oral presentation because I think it's too well known to be interesting for you. However, I examine it in my written paper. Conversely, the linguistic dimension of fundamental freedom and of the right of equality seems to be the subject of an evolving and broadening interpretation. Therefore, I will concentrate my presentation on this second point. The second important distinction is between private and official use of languages. In the international law of human rights, as well as in the constitutional law of liberal democracies, two areas are distinguished in the use of languages as regard the legitimacy of constraining or coercive state interventions. The private use of languages in which the greatest possible freedom should be allowed, and the official use of languages in which a state can legitimately impose one or more languages. The private use of languages encompasses all cases where the language is not employed in the relation between individuals and state organs or representatives. It includes intimate situation or public usage, the publication of books and newspapers, theater and cinematic performances, political conferences and meetings, all commercial and economic life, according to this point of view, constitute so many private use of the language. And in this vast field of the private sphere, the individual should be as free as possible to employ the language of his choice. This linguistic freedom flows implicitly from fundamental freedoms, in particular freedom of expression and from the right to equality. And it is thus not necessary to expressly guarantee such a freedom in a particular constitutional or legislative provision. However, as with any other right of freedom, this implicit freedom is not absolute. It can be limited in reasonable and justifiable ways. And in this respect, it is useful to make a new distinction between internal private use and external private use. Internal private use is about relation within the family, between friends, in social life. And in this area, linguistic freedom should be absolute, by virtue of freedom of expression, personal freedom, and the right to respect of private life. The external private use is about the language that people use when they express themselves in the public sphere or address themselves to the general public. It includes, in particular, all of private economic life, for example, commercial advertisement or the labeling of consumer products. And in this field of the external private use of languages, the state can regulate the use of languages insofar as it pursues a legitimate goal in the public interest, for example, to protect consumers or workers in the respect of the principle of proportionality. If we turn now to the official use of languages pertaining to the relations between private individuals and the state, its agencies and representatives, no right of an individual to the choice of language can be considered as originating from fundamental freedoms or from the right to equality, with one exception, with the exception of the right to an interpreter for people who do not understand the language used in court. If such a right is not guaranteed in express terms, which is often the case, but if it's not guaranteed in express terms, such a right can be considered as deriving from the right to the basic right to a fair trial. In the sphere of the official use of languages, the state may impose the use of one or more particular language or languages. This, of course, by no means excludes that a certain right of individuals to choose the language of their relationships with the state can be guaranteed by particular provision in a law or constitution or an international instrument, which will then contain special linguistic protection. And such is precisely the case for the Canadian constitutional provisions that relate to the use of English and French as official languages, which have been explained to you by André Brun. However, what is important that such special linguistic rights must be expressly provided for. They cannot be regarded as originating implicitly from fundamental freedoms or from the right to equality. So let me now examine the scope of this linguistic freedom that derives from general human rights guaranteed by international instruments. And as we will see, in the current state of the law, such a linguistic freedom remains insufficient for the linguistic minorities because it traditionally is regarded as applying only to the private use of languages, as opposed to their official use. That's the current consensus. However, as I will try to show you a little later, this current consensus, this restrictive point of view, is sometimes now called into question. Okay, so I will begin with the current consensus, which is illustrated by the Ballantyne case, which has been heard by the Human Rights Committee, the United Nations Human Rights Committee. Current consensus, which is to the effect that the linguistic freedom that can be derived from general human rights exists only for the private use of languages. And perhaps I begin by recalling something about which André already has spoken, the case of the Ford case in Quebec of 1988. André told you that when it was adopted in 1977, Quebec's Bill 101 imposed, subject to certain exceptions, the exclusive use of French for public signs, commercial advertising, and firm corporate names. And he recalled you that in 1988, in the Ford case, the Supreme Court of Canada considered this requirement as a restriction of freedom of expression, as well as creating an indirect discrimination against those whose usual language was other than French. Now, what is interesting for us from the international law point of view is that a few years later, in the Ballantyne case, the United Nations Human Rights Committee came to the same conclusion regarding the infringement of freedom of expression, but this time, of course, by applying Section 19 of the International Covenant on Civil and Political Rights. And you know already that following these decisions of the Supreme Court and the UN Committee, the government of Quebec adopted a new regime in which public signs, commercial advertisement, and commercial names now can be made in another language as well as in French, provided that the text in French is markedly predominant. Bon. Now, let us analyze the Ballantyne case. In the Ballantyne case, after finding an infringement of freedom of expression, the members of the UN Committee, by a majority, were also of the opinion that the provision of the Charter of the French language imposing the exclusive use of French were contrary neither to Article 26 of the Covenant, right to equality before the law, nor to Article 27 of the Covenant, rights of persons belonging to ethnic, religious, or linguistic minorities. Now, what I would like to show you is that the reasoning which led the majority members of the committee to reject the arguments based on Article 26 and 27 of the Covenant, the reasoning is not very convincing, and that the committee could very well change its opinion in the future, which would, of course, increase the vulnerability of the Charter of the French language and other similar linguistic policies, like that of Catalonia, with regard to the Covenant. So let's first take a look at the argument that were used to reject the claim based on the right to equality and the prohibition of discrimination. In order to reject that argument, the majority in the committee considered that the requirement that the language of public signs and commercial advertisement be only in French, such a requirement did not amount to discrimination between the various linguistic groups because it applied to all persons, irrespective of their usual or preferred language. This means that in the opinion of the committee, or at least of the majority members of the committee, a rule of general application imposing the exclusive use of a given language on all persons constitutes equal treatment. However, such a vision seems to be in contradiction with the view that the committee itself expressed in its general comment on non-discrimination, where the committee defines discrimination as, quote, any distinction, exclusion, restriction, or preference which is based on any ground, for example, language, and which has the purpose or effect of nullifying or impairing the recognition, enjoyment, or exercise by all persons on an equal footing of all rights and freedoms. This definition implies, of course, that the committee recognizes what is called adverse effect or indirect discrimination, which means discrimination caused by a facially neutral rule applied in the same way to everyone, but which causes adverse effects on a group because of one of the prohibited grounds of discrimination. And as we have seen before, in the Ford case, the Supreme Court of Canada was precisely of the opinion that a provision imposing on everyone the exclusive use of French in commercial advertisement amounted to indirect discrimination based on language against those whose language was other than French. And we know all that the analysis of the anti-discrimination norm as prohibiting not only direct but also indirect adverse effect discrimination is now widely accepted. As regards rejection by the committee of the arguments based on Article 27 of the Covenant, which protects in particular the rights of persons belonging to a linguistic minority, in common with the other members of their group, to use their own language, the question is more complex. The committee ruled by a majority that Article 27 applies only to groups forming a minority on the national level, and not to groups like the Anglophone in Quebec, that although constituting minorities in a regional area, on a regional level, belong to the majority on the national level. However, this majority position within the committee was the subject of a vigorous dissidence by 4 of its members, and this position has also been criticized by a number of academic commentators who consider that the most important consideration should be the fact that a group in numerical situation of inferiority is politically and legally subject to decisions that can be taken with regard to its interest by another group which forms the majority in the concerned jurisdiction, even if this jurisdiction is not at the national level but is a component unit of a state, either a region or a federal entity in a federation like Canada. And a similar position was adopted by the Venice Commission of the Council of Europe in connection with the situation of linguistic groups in Belgium, and thus the question cannot be regarded as finally resolved. To complete this examination of the Ballantyne case, it must be noted that the Human Rights Committee reiterated the position well established in international law, according to which states, if they must respect a certain linguistic freedom in the private use of languages, may also legitimately impose one or more languages for the official use, for official purposes. Thus, the committee declared, quote, "A state may choose one or more official languages, but it may not include outside the sphere of public life the freedom to express oneself in the language of one's choice," which means, this citation means, at least by implication, that the state is not obliged to grant official language status to minority languages, nor, which would amount to the same, to use such languages in its relations with private individuals. Thus, to complete this analysis of the Ballantyne case, one can consider that in this case the Human Rights Committee gave expression to the traditional consensus holding that the linguistic freedom deriving from human rights exists only for the private use of languages. Now we will see that this traditional consensus is subject to criticism and that it is perhaps even undergoing a change. So let me now examine the challenge to the current consensus, and the question is the following. Should human rights be applied so as to impose certain linguistic obligation on the state as regard the official use of languages? And I will begin by examining the position which is presented by certain authors and by some international bodies, position based on the concept of indirect adverse effect discrimination. The question is it possible, on the sole basis of the prohibition of discrimination based on language, to question the current consensus and to impose upon the state the obligation to use languages other than its official languages in some of its functions, like justice or public education? And precisely, such a position is adopted in academic writings, like those of Professor Fernand de Varenne, for example, and by international organisms like the OSCE High Commissioner on National Minorities. And the argument is based on the concept of indirect discrimination, which I previously have examined. And the argument goes the following way. The argument is the following. The policy of offering public services only in the official, which means the majority language, causes a disadvantage to those who speak a different language and thus creates a form of indirect discrimination. And the argument goes along, to avoid such discrimination, public authorities should have the obligation to use also languages other than the official language, at least when these non-official languages are spoken by a large enough number of people, and when granting such rights to the minority does not come into conflict with another preeminent state objective. Indeed, those who defend this position admit that the state can legitimately take account of financial and practical consideration, as well as of the need for the existence of a common language in order to foster social integration and solidarity. And taking into account these different factors, the rights recognized to linguistic minorities as regard the official use of the languages should depend on the numerical importance and geographical concentration of the members of the minority. There should be a balance between, on the one hand, rights of the minorities, and on the other hand, practical financial consideration for the state, as well as the need for a common language. We will now see, I will now try to show you that in a case that was considered after the Ballantyne case, a majority of the members of the United Nations Human Rights Committee seems to have adopted a position similar to the one I have just explained. But at the same time, I will try to show you that the reasoning used by the majority seems weak, and that it has been the subject of a very strong dissent within the committee itself. So let me now examine the opinion of the majority member of the UN Human Rights Committee in the Diergaard case. In the case of Diergaard versus Namibia in the year 2000, a majority of members of the committee, UN Human Rights Committee, was of the opinion that an administrative circular of the government of Namibia prohibiting that civil servants use a language other than English in their official communication with citizens, even on the telephone, amounted to discrimination contrary to Article 26 of the Covenant. And you must know that, according to the Constitution of Namibia, English is the only official language. Thus, the majority opinion seems to imply clearly that a state commits discrimination as soon as it refuses to communicate with private citizens in languages other than its